All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas and this honorable court.
Please be seated. Good morning. Welcome to the Supreme Court of Texas. We'll hear argument in 4 cases this morning. The first case is number 240310, HEB versus Peterson from Bexar County and the 13th Court of Appeals. The second case is 240881, in the interest of KN and others, from Gray County and the 7th Court of Appeals. Next will be 240883, in re Bell Helicopter from Galveston County and the 14th Court of Appeals. And finally, 241062, in re Toffel from Dallas County and the 5th Court of Appeals. The court has allotted 20 minutes to each side in each of the cases. We'll take a short break between the arguments, which can be viewed online and will be available on the court's website later today. And with that, we're ready for argument in case number 240310, HEB versus Peterson.
May it please the court, Mr. Jefferson will present argument for the petitioners. Petitioner has reserved 5 minutes for rebuttal.
Mr. Chief Justice, and may it please the court, I think it'll be helpful for the court to have in front of you the respondent's exhibit. It's tab 2, and there's a picture of the HEB grocery store. It's about a 60,000 square foot facility. And you will see on this graphic on the left, there are a lot of small structures, and these are units, refrigeration units that were being remodeled before this incident that happened. About 40 feet to the right of the last unit is where the incident took place. That's the store aisle. It's not depicted here, but for myself, I've drawn a rectangle around it, about 40 feet to the right of the last unit. This is a case in which there is no evidence, actual or constructive, that HEB had notice of a premise condition that caused Peterson's injuries.
Hadn't the roof had at least 170 different leaks that had been identified?
170, and maybe even more than that, Your Honor. But those leaks happened during a remodeling process, and the reason I showed you this exhibit is they were replacing the refrigeration units, and the subcontractors, this is 40 feet away from the store aisle, were punching holes. They shouldn't have been, as they were replacing these units. They're heavy units, and these caused leaks. And so there are a bunch of reports and inspections that show those are leaks. HEB calls the subcontractor to repair them over and over again.
But if you're going to have that many leaks for whatever reason, because they were doing this, that, whatever, wouldn't that put them on notice that they need to check the whole thing out?
This is one building here. If there are leaks in the Court of Appeals, which is down the hall, that doesn't mean that we should be looking for leaks here in the courtroom. And this is the point. Where are the leaks?
Are you saying they were all focused on where those units were, all 170?
That's right, and none focused above the toy aisle, not one.
Or anywhere else? Or
Nowhere else but...
I mean, where were they? Do we know where they were on this map? These
Yes.
170, where are they?
Yes, they're as I showed you. You saw those structures. These little square boxes are refrigeration units. When they put those in, the subcontractors, they weren't the best, they weren't ours, it wasn't our building, we were leasing it. But the subcontractors put holes over here.
the southwest quadrant is what we're talking about? Basically?
Yes.
Okay.
But where the toil aisle is no leaks. And so the question is,
And where on this exhibit is the toy aisle?
so here are the boxes that we're
Yeah.
talking about. If you go over 40 feet, it is in a square rectangle. The toy aisle is right here.
Okay.
So you need to have the store say clean up on aisle 9 before there's constructive or actual notice that there's that there's something that they need to attend to there?
In City of Rodriguez, the manager of the gym closed the gym that morning from 8:30 to 3:45. Why? Because there were leaks from rain that morning. He knew. He opened it when he thought the rain was finished and it wasn't going to happen again, but it did. There was evidence, at least, that it did. But that facility was a recreation center. He wouldn't have worried if the leaks were in the classroom.
So I thought that was an actual notice case, right? About
It was a constructive notice case.
whether there was actual notice depending on the position of the leaks above the floor.
There was actual notice that morning. There was constructive notice because of the prior leaks in that vicinity, right above, in the same area where it leaked before.
So how many leaks is enough that you have to check out the whole store?
Well, if the accident here happened where the refrigeration units were, I don't think it would take many. But the leak that we're talking about here, if you accept their evidence that she saw water leaking, that could have been the very first time. And we don't know how long the water was on the floor.
Were there
from that
any
leak.
leaks of these 170, were any of those leaks, even one, outside of the areas that you're identifying?
Zero, the evidence doesn't show.
In the record.
In the record, anything other than in that area that we've identified.
Well, Mr. Wayne testified that there were white trash cans and buckets of water in several places around the store, but not in the toy aisle.
Correct.
I mean, if you need a trash can to hold the water, that's a lot of water.
You have negligent subcontractors above the area that was produce area, dairy products, far away from the toy aisle. And in that area, you better have buckets, you better have mops, and you better warn employees and customers that are coming through that area. But in the toy aisle, nothing. We have 1,700 pages worth of inspections and reports and all of this. None have anything to do with the toy aisle.
So I think that the respondents say that imposing a vicinity requirement would not change the outcome of this case because you can combine the evidence of the dripping from the ceiling with evidence that the rain had stopped 2 hours earlier to know that there had been water present for 2 hours, and in their view, that's enough to create a fact issue on constructive notice to the jury. What is your response to that?
Well, there are a couple of responses. Number one, the plaintiff has not to this day connected a leak in another area with the water puddle in this area. That is
Right.
complete.
And say, take that as a given, and they say, look, even if that's true, what about this leak that was observed from above the toy aisle at the time of the accident?
I would ask counsel and I would ask the court, when did that leak occur?
And can we infer from the stopping of the rain that it had been ongoing for a couple of hours, or no?
So the rain that occurred was 0.03 inches 2 hours before this accident occurred. In the City of Rodriguez case, it was a heavy rain. The rain that occurred was almost 6 miles away from, that was reported at the airport, almost 6 miles away from this HEB store.
So why did they need trash cans and buckets if it was only 0.03 inches?
There was no trash cans and there were no buckets under the toy aisle.
Well, but presumably 0.03 inches of rain fell on all parts of the roof, and
All
I
parts-
wouldn't think that you would need a trash can if it was only 0.03
Let's
inches
assume,
anywhere in this.
let's assume it was, let's even assume that it was a heavy rain and that the areas that were leaking before required trash cans and buckets, again, beneath the refrigeration units. That's separate and apart from the toy aisle.
Wasn't there some evidence that the HEB, in addition to its normal protocol because of the leaks, had said that people should go around and check for leaks after a rain?
There's evidence of that, and there's also evidence that happened.
There's also evidence that it didn't, because the camera shows nobody checking the toy aisle.
There's video evidence. At 9:13, videotape shows an HEB employee with a badge was near the toy aisle. This is about 15 minutes before that leak.
Well,
But
our understanding of the record is that the video shows there may have been an employee near the toy aisle, but there was nobody checking in accordance with their policy.
Let's even assume that. Okay, this is a summary judgment case. So I think it's our responsibility to say, you are going to look at the record in the light most favorable to the plaintiff. So let's take that as the light most favorable to the plaintiff, that there was heavy rain, that there were buckets, and that the inspection didn't happen according to our policy. Take all of that as true, as exactly true. Where is the evidence of how long the substance here had been on the floor prior to the fall that would give HEB notice that it needed to clean up that specific aisle when it had any inclination that there was a reason to check the toy aisle? There may have been a reason.
That's why they had isn't a policy some evidence of what a reasonable owner would do?
A policy in every store is to, including
Well, but this store, they had an additional policy.
In this specific store,
Right.
again, let's take the evidence, Your Honor, in the light most favorable. The evidence was that HEB, they call them partners, are supposed to constantly inspect the stores. But constantly doesn't mean every second. It doesn't mean every 30 seconds. That kind of policy, if you were to write that into law, the burden on premise owners in the state of Texas would be enormous.
But I think the video showed a couple hours, didn't it?
The video doesn't show how long the puddle on the floor was.
No,
We
but
dispute that there's a puddle at all.
No, but that it had been a couple of hours.
Where
nobody had.
I'm saying, let's assume, again, the plaintiff's best case, that no one had ever walked in that store aisle the whole morning, not once, okay? Let's assume that's the case. Let's assume that's true. Let's take their evidence as the best possible evidence. What evidence is there that the puddle had been on the floor long enough for a reasonable inspection to have discovered it and cleaned it up? And the answer is there's no evidence. The evidence would be that there would be, under Rodriguez, an obligation to check under the refrigeration units. Yes, for sure, 170 reports, but
I
nothing
thought you
in
were
that area.
assuming that somebody should have checked the aisle. So we're getting away from the refrigeration units argument. We're assuming that somebody should have checked the aisle. But I take your point. The question is, what evidence was there that if somebody had walked in the aisle, they would have seen it?
And so on that, when I talk about conjecture, the question is, how long had the leak that we dispute, but we're going to take as true, that she saw leaking from the rafters? She said, how long had that been occurring? Could it have been 30 seconds before she walked into the aisle? The answer is yes. Could it have been the very first time there was a store leak in the aisle, in the toy aisle? The answer is yes to that.
If the record were a little different than what I guess it is, I hadn't realized that it was just that southwest quadrant where all of the leaks, all those 1,700 pages were about. But if the record were a little bit different and there had been some leaks, mostly in that quadrant where the units were above it, but occasionally somewhere else in the store, would this all be different or not?
If we say occasionally somewhere else in the store, I think the answer is no. It would have to be in the area, or there'd have to be some connection between the leaks elsewhere and the puddle here.
Well, if it's like every time it rains, there's a leak, and instead of it always being concentrated here, which is a good fact for you if that's right, but that it's going to be somewhere. And it's never been in the toy aisle yet, but every time there's a leak, and we never know where it's going to be, but there's going to be a leak whenever it rains. Just assume that scenario. Would that mean, though, that you would have some different kind of responsibility with respect to the toy aisle because you know for sure there's going to be a leak somewhere and somebody's going to be slipping on a puddle?
If you say everywhere there's been a leak, but never in the toy aisle,
right,
then I would say no. The obligation would be where there's a leak, you inspect.
But how can that be right? That's say, you know, we've got this building, and every time it rains, sometimes it's in the clerk's office, and sometimes it's in the courtroom, and sometimes it's in the Court of Appeals, and sometimes in the Court of Criminal Appeals, and it's never yet been in my chambers. But it's been in hers, and it's been in his, and you're just gonna say, well, we have no reason to expect it could ever be in Justice Young's just because there's a leak every single time it rains, and it's in a different place every time, but who could ever imagine that it would be in Justice Young's this time? That's your argument?
No, the argument is, on this record, it's.
No, under my hypothetical that it's just in different places.
And there's no.
In the HEB.
And there's no cause for it?
Just that we know that every time it rains, there's gonna be a leak somewhere in this
If
store.
there's
and that
just
it's
if you just
sporadically-
have a bad roof, you should be inspecting for leaks. I mean, if that's the case, you should be inspecting.
So it's
for
never been
leaks.
on the toy aisle yet, right, under this scenario, but we know it's been in the one next to it, and we know it's been on the one on the other side. Would you still be able to say, well, the fact that it hasn't happened in the toy aisle has any meaning at all?
This is a football field we're talking about. You know, this is 60,000 square feet. So if it's on the 15-yard line, but not on the 15-yard line on the east side, I would say no, there's not an obligation.
Well, if it's been on the 20-yard line and it's been on the 25-yard line, would
Yeah.
we say, well, it's never been on the 15-yard line?
Yeah, I mean, it looks like they were on the 40 and the toy aisle was at midfield. I mean, if I'm looking at it right here.
There's another photograph 4 pages back from the one you were referencing that has many, many yellow squares all across the building. And so if you had, I don't know what the record shows that this depicts precisely, but if you had a roof that was essentially Swiss cheese like this, I mean, there has to be, can you offer us a limiting principle for when the vicinity requirement has to give way? Not saying that's
No,
this
no.
case, because I'm not sure what these yellow squares depict on this record, but
I think the limiting principle would be there must be some connection between the leak in these other areas and the pool of water wherever it is. Now, I would say, we don't even know that this leak came from a rain leak. It could be a busted water pipe. We just
why
don't know.
don't we have to take the plaintiff's evidence, though?
The plaintiff's evidence
it was
is
leaking
she
from the
saw
roof.
water leaking, but there's no evidence that.
From a rafter,
That it
right?
was.
From the
right.
raft, necessarily that it was.
Looks like
leaking.
on this diagram, the rafters run left to right. It's pretty common for water to run down rafters after it leaks through a roof, right?
This is a sloped roof, and which is intended not to permit pooling. But again, even assuming there was a leak for the very first time in the toy aisle, there's no evidence that HEB had any kind of knowledge of it. And
Your policy that about checking for leaks after the rain, because of the unique circumstances of this store and all the leaks, didn't say don't check the aisles where you haven't seen a leak yet, right?
the policy didn't say don't check the aisles.
Yeah, I mean, you're saying we didn't have an obligation to check the aisles, but what they were doing was checking the whole store, right, for leaks after a rain?
My point is not about the standard of care for checking aisles. My point is this court has never once deterred from the obligation on a plaintiff to show that the premise owner had actual or constructive knowledge. And if it's constructive, it has to be based on something. It can't just be conjecture. It can't just be surmise or suspicion. There has to be evidence, direct or circumstantial. And here, there's no evidence anywhere in this record that would show that the leak occurred, that HEB had noticed that there would be a leak in the toy aisle, and no evidence whatsoever that HEB was aware of this substance on the floor. That's their obligation. It's not a heavy burden, but it is a burden.
If there had been a leak above the toy aisle, but had been completely fixed, you know, best contractors, best roofers, et cetera, and then this happened again and there was another leak 6 months later, would you think that that vicinity, the fact that there had previously been a leak, would be in any way probative of the ability of HEB to expect a leak 6 months later?
I'll take your hypothetical that it was completely fixed, then I would think there is no obligation.
Right.
Rodriguez is the case to look at this. point. And I commend the court to look not only at the opinion in Rodriguez, but look at the briefs. I went back and pulled the briefs in the city of San Antonio versus Rodriguez case. It's on microfiche, okay? But it shows that the store was aware of the leak in that area right below where the leak happened.
It had
on
not
the
been
gym.
fixed.
Had not been fixed, and it happened that morning. And the accident happened that afternoon. That was the state of the evidence there. And that's why the court said there's got to be some kind of proximity, and reinforced that in the Corsicana case later. It was a different issue, immunity, but the court recognized this as a vicinity requirement. And I think otherwise, the burden on the plaintiff is not great to show that proximity. But otherwise, in every storm, in every light rain, it doesn't matter, then every premise owner, whether it's the convention center or an HEB, has to have constant surveillance. And by constant, I mean they've got to have an employee stationed there every 30 seconds. That's why the tort system exists, to require burdens of proof, and they just didn't meet it on this record.
Thank you, counsel. Any further questions?
I guess just one thing I wanted to ask is, with these rain events, it seems like it could be kind of a zero-sum game, like the water's got to go somewhere. And so, I take your point that, if the third court has a leaky roof, maybe we're not on constructive notice that the Supreme Court roof would leak. But if the third court's roof gets patched up, that water's got to go somewhere, and if the answer is more water comes over here, I don't know, it seems you could be on constructive notice that, other parts of the roof are going to start leaking because of the repairs you made to the other section, right?
Yes, but you build the roofs to think about what's going to happen when it rains, and so they're sloped and there are gutters and the water is directed. That was true in this roof. The recreation center in Rodriguez, not so. It was a flat roof and water pool. You anticipate these sorts of events and you try to remedy them. The court, this is not a res ipsa loquitur situation in which if it rains and there's a leak, there's liability anywhere in the store. If that were the case, the sort of liability that you're putting on mom and pop shows, stores, and convention centers is limitless, it's boundless, and I think that's not where this court should go in a case like this. Thank you.
Thank you, counsel. We'll hear from the respondent.
May it please the court, Mr. Sloan will present argument for the respondent.
Mr. Chief Justice, may it please the court. The bench book, tab number 1, this is out of the 1,700 pages of roof records. And what we've done is we've pulled, each time the roofing company was called out, they submit this picture of their invoice and they circle all of the leaks.
Let me ask you, on this one that Justice Petal had referred to on page 138.
Yes, ma'am.
What is that? What are the yellow spots?
As my understanding, Your Honor, is these are leaks. And if the court, the 1,700 pages was on CD, I talked to the clerk's office last week. I don't know if those made it up here, but they're at the 13th court. And so
these are the leaks.
Is my understanding, and where they were approximately where they were repaired.
And how was that in the record?
The photographs, it was just all in these records. So then subsequent to 138, there's pictures of the patches that they did, the temporary patch and then the permanent patch that they came back. And on this 138 page, my understanding, the toy aisle is about in the middle of the picture where those two parallel bars are. It's roughly where we're talking about, and you can see there are patches. Now this picture, based on page 139, was from January of 2016, which would get to Justice Hawkins' point, or Justice Young's point about it being repaired several months before, and are they on notice of that? So when you look at the bench book, and the reason I put these pages in here is not so we can get out our Allen scales and measure where the leaks are in relation to, but so that the court can see it's not limited to the southwestern quadrant.
Are these, on this particular exhibit that Justice Petal had brought to our attention, are those any of the 170 leaks that the record talks about, or any of these yellow ones?
Yes, ma'am. These are all of the 170. All of the pages.
So they're the one we're talking about. It's just not leaks that have been there.
All of the pages in the bench book are predate Mrs. Peterson's fall, and they each have different circles on them, different leaks, and the court can thumb through here to see that they're not limited to one portion of the store. They're on the front wall, they're on the back wall, they're on the north end of the store, they're on the south end of the store where the refrigeration units are
How
concentrated.
long before the event in this case was there a leak that was outside the southwest quadrant that your friend on the other side is saying most of the leaks occurred in?
I don't know the specific answer to that. I know the page we're looking at, 138, is dated January. I know there are leaks in the middle of August. There's a repair record in the middle of August, and then she fell on
That's
Labor Day.
outside of that
On Labor Day
southwest
weekend.
quadrant?
I'd have to look at the exact location of where those are, Your Honor. I don't disagree that there had never been a leak identified directly above the toy aisle.
Can you tell us about what the evidence shows about what HEB's heightened protocol or practice was, knowing that these leaks, what did they tell their
Right.
people to
So
do
in
in
Mr.
this
Mark-
store that was different from other stores?
Right, in Mr. Marquis' deposition, I asked him what they do in a rain event, and he said they put out the yellow cones at the start of the store, they put out extra floor mats, then they have someone walk the store to check for issues. He didn't specifically say for leaks. HEB in their brief said that he later mentioned in his deposition that he's looking for water coming off carts or umbrellas. I think that mischaracterized his testimony a little bit. But they're obviously looking for leaks because they're reporting them to the landlord and the property manager to get them fixed. So they've done,
Putting out white trash cans.
right, to protect their customers from slipping and falling on puddles of water.
If having a policy to carefully inspect the store and protect customers from leaks creates some kind of heightened liability standard or expands your constructive notice of leaks, aren't we disincentivizing those sorts of policies?
I don't think so, Your Honor, because I think in this particular case, the policy at issue shows that HEB is aware this roof is a problem. I don't think this is a widespread problem that all of a sudden we're going to have these types of cases at every Walmart, at every Home Depot, at every large box store retailer. But at this store, they know this roof is a problem. It leaks every time it rains. That's the testimony from the property manager.
If we say something to the effect of, well, you had a policy to, check carefully and you didn't, and that somehow contributes to your inability to liability here, I think the world digests that as, well, we shouldn't have such policies and we shouldn't be looking.
I think that's one step. That's one way to read that policy. The other way to read it is that they do the inspection, they find these leaks anywhere in the store that they may be, and they put out the trash cans or the other water diversions so that these things don't end up on the floor to create the hazardous
How quickly do
condition.
they need to find the leak, in your view?
I think that's
to
a
avoid an allegation of constructive notice?
I think that's a fact question for the jury to determine. What is that reasonable period of time?
But
In
we,
the third
with
tab,
macaroni salad and grapes and all kinds of things, have said it's not a fact issue for the jury. Our jurisprudence doesn't seem to, there seems to have to be something connecting the constructive notice to the actual defect, which is the water on the floor.
correct. And so in the third tab of the bench book is the McCarty versus Hillstone case, which is a Fifth Circuit case. It's not precedential, and it actually doesn't find constructive notice. But the Fifth Circuit analyzed both the Rodriguez case and the Tinsley case, which is cited throughout. And it says that the jury gets to make that inference, that based on when the leak stopped, when the rain stopped in this case, which there's no evidence in any of the other cases that have been cited by either party as to when the rain started or stopped. So in this case, we know it was a period of 2 hours. And then that gets to Mr. English's opinion that a reasonable store owner is going to perform these inspections, whether it's
But I
every...
think the petitioners say that there's nothing in the record linking this particular puddle and water dripping from the rain that stopped 2 hours earlier.
The HEB incident report drafted that night by the store manager says that the source of the substance is water and the source is rain, combined with Mrs. Peterson's testimony that she saw water dripping from the ceiling, I do think combines to create at least a fact question, more than a scintilla of evidence, that the source of this puddle on this evening after this rainstorm was the rain and the leak in the roof.
Is anything in the record indicate what the dimensions are of this, or were at that time, of this toy section? Was it by 8 by 8, 2x2, 10x10?
No, ma'am, I mean, the toy aisle, the video surveillance shows that the aisles run, I guess, perpendicular. If you were looking back at the bench book, they run front to back in the store. In this particular one, it's a standard width grocery store aisle.
And it's just one aisle?
This particular location that HEB has zeroed in on to say there's no leak above this particular aisle. So what is that, 3 or 4 feet across and 30 feet long, plus or minus?
And the policy that we're talking about, was that a policy that was restricted to this store?
So far as I know, yes, Your Honor, from the bench book.
So your friend on the other side says, even assuming that they should have had somebody check the toy aisle, there's no evidence of how long the puddle was there, and so they could have walked by and wouldn't have seen anything. What's your response to that?
I guess that gets back to the Fifth Circuit case and the Rodriguez opinion and the Tinsley opinion, that it takes time. If we're going to accept Ms. Peterson's testimony that the drips and the rain, that this is a puddle, it takes time for a puddle like that to form from drips of water. To the extent that puddle was created from a large influx of water at one time, the Tinsley case, and the Fifth Circuit seems to cite with approval, would say that's on HEB to show that this was all of a sudden created. When the evidence indicates that this is formed from a drip from the ceiling that occurred from a roof leak, then the constructive notice would say that that has grown over a period of time and stopped raining 2 hours before Mrs. Peterson fell. I think it's the inference there is that the leak started at least the time it stopped raining.
You mentioned the fact that the HEB, after action report identified the substance as water and everything. In our per curiam last year in Albertsons, it was also the case. The manager also testified that he did not notice any liquid when he inspected the floor before and after Mohammadi's fall, despite claiming to have observed liquid on the floor after the accident in the report he made at the time. Now, that was a jury trial case, but how much does the report in this record from HEB matter after something like Albertsons?
The Mohammadi case, the Albertsons case, one, they're kind of trying to fit a round peg into a square hole in that case because they were asking this court to say Albertsons had actual knowledge of the water on the floor, and the court comes back and says actually they probably had constructive knowledge based on putting the leaking bags in the cart, but they tried that issue to a jury and the jury said that they didn't. Mm-hmm. So in this case, the store manager is a 45-year employee from HEB. Certainly he's filled these things out. If he didn't know where the water came from, he has training on that, and I suspect in that document he can write down unknown. I don't know where the water came from, but it was his choice to fill that out. That's not Ms. Peterson's report.
Does the constructive knowledge standard, because it's an objective standard, right? Would the standard slide based on whether it was a 45-year partner of HEB versus the new guy at Piggly Wiggly?
I would hope that the store is going to train their employees on how to fill these out, and the employee filling them out is going to have some understanding of what to put there. And if they know where the water comes from, or the substance comes from, they can write that down. They can put that in a report. And then if they don't, they have the opportunity to put it unknown. I think it might be different if this were Mrs. Peterson's report and she had filled it out for them. But this is a report that their store manager.
Yeah, whatever the objective standard is, they ought to know the difference between water and, as Justice Bland mentioned, grapes and macaroni salad. Okay.
Yes, sir. I would posit to the court a hypothetical where someone walked down the aisle and at 7:30 and poured a bottle of water, and we could prove this with evidence, and someone poured a bottle of water on the floor and then it didn't get cleaned up for 2 hours. So that, in that particular hypothetical, the question would be for the court, is that 2-hour period long enough that they should have discovered the water? And I think that's where Mr. English's opinions come in, the ones that the 13th court put back into the record on a reasonable inspections, reasonable protocols. That's where his testimony comes in, and they can then disagree with those if they want to. In getting to some of the cases that have been cited, The vicinity requirement, I think, creates a problem in the Rodriguez case, for example. That's a recreational center where you're talking about a basketball court. And to build on the court's football analogy, if it's raining on one end of the basketball court, does it count for the other end? Am I on constructive notice on the other end of the basketball court? Clearly, I can see all the way across it. The Peperinsky case out of Dallas, that's a 600,000 square foot facility. It's 10 times the size of this HEB based on the 60,000 square feet we heard today. So this HEB is in a shopping center. I don't contend that a leak in the Barnes & Noble 4 doors down is going to put HEB on notice of leaks within its store.
It's the transient nature of these kinds of hazards that present this challenge for the law, because if the hazard is sort of ever present, constructive notice on a landowner is easier because it's ever present. But here we have puddle here, puddle there, and so how do we craft a rule for constructive notice that affords some appreciation for the transient nature of a puddle?
Respectfully, Your Honor, I think the court already has. In the Walmart v. Reese case, it's kind of identified what can qualify as a constructive notice in this, and that substance has been on the floor long enough for someone to have discovered it. And so to go into a vicinity requirement, I don't know what those guardrails look like. You have a 60,000 square foot store here, but you have a mom and pop bodega in the mall that's only 20 feet wide. So is it going to be radius based? Is it going to be inside of your particular store, inside a big open room like this one? Does a leak in this room count for that room? Does the leak does it matter that we're on the underside of the roof versus the top of the roof? Because there's evidence in the record that the water may penetrate the ceiling, the rubber top, and actually come into the building envelope somewhere else. So where does the vicinity start to matter in that case? And that's why I think the fact-based inquiry that the court has established from Reese, which I think the Court of Appeals thoroughly looked at in this case, to list out all of this evidence, to say that based on all of these things in this particular store after this particular rainstorm, we have met it. I'm not sure that this case is the one that lends itself to a large sort of broad-based pronouncement of the law, because I do think this is so out of the ordinary with the number of roof leaks and the problems with this store.
Roof leaks in grocery stores are not unusual.
No, ma'am.
Anyone who shops in a grocery store routinely on a rainy day.
Luckily, we have less of those in San
whatever we say is going to be important because stores have leaks.
Absolutely, and I think I would almost contend that the leak is maybe less important, Your Honor, because we certainly know the leak is not the dangerous condition. The dangerous condition in this case is the water on the floor. And the water on the floor originated from a leak, but now it has been on the floor for a period of hours, and no one has found it. So I would think that this would just go back to the traditional elements of constructive notice. And is that 2-hour time period that the water has been on the floor, is that sufficient, that this puddle has been growing? Is that sufficient to put a grocery store? This isn't a 30-second question. This isn't started raining at 7, she fell at 7:15. This is it stopped raining at 7:30 and she didn't fall until 9:30, 2 hours later.
If you were writing the opinion, what's the one sentence encapsulation of the rule that you would put forward for, how liability would be established in these leak situations?
I was going to say affirmed, but I would, again, go back to the Walmart v. Reese opinion and say that this requires a fact-based inquiry. And based on the facts in this case, the severe number of leaks, the interior policy that they had, the time the water was on the floor, all result in this particular case that Mrs. Peterson has established constructive notice for
So if a
HEB.
premises owner is aware there's been a lot of leaks in the roof, they have a duty to walk the store every X many minutes and see if there's a puddle somewhere? I guess I'm trying to figure out like how this would apply in other cases that don't involve these same facts.
I don't know that there's a minute requirement, Your Honor. I think maybe that's a sliding scale based on the amount of leaks, the amount of problems they've had, the location of the problems that they've had throughout the store. Certainly going to go back to those areas first, but you know that there are leaks other places. So I think it gets back to what is a reasonable standard, what is a reasonable store owner going to do in a situation where they know they have this many leaks, they know they have this many problems.
So on this day in question with these 100 and however many, 70 leaks, were there actual drips on that day from these other leaks?
From the other leak, so Mr. Wayne testified that there were buckets throughout the store. I don't know that he testified that there were drips coming into them throughout the store on that day, but he certainly said there were buckets.
So there wasn't any evidence about whether
there were other leaks in the store on that day. I don't believe that there's any evidence in the record of that.
I don't mean just, that water was actually coming through.
Yes, ma'am. I don't think there's any evidence of that.
Did he say there were buckets of water? I'd have to go back and look at his testimony.
I don't think it was of water, but buckets placed throughout the store.
And white trash.
The implication, I think, if it's not direct in his testimony, the implication was they were catching water with buckets other places.
Of the 1,500 pages of repairs, were there any that happened immediately after this day's rainfall?
There's a gap. It's monthly. I think we asked for a year before and a year after, and it's coming up to August 15th is the last one, I believe, before she fell in early September. Then there's a bit of a gap, and then they come back monthly again after that. So the roof problems continue even long after.
It's not like
Mrs.
after this
Peterson.
rainfall, there was a spate of repairs or anything like that.
Not after this particular rainfall, no.
If I could come back to Justice Hawkins' question about hypothetical Judge Sloan, if I could give a note on it sounds like your proposed sentence for the opinion of the standard that we should apply here is the facts matter, so let a jury decide.
In so many words, Your Honor. Given this, again, set of facts, that all of this evidence combined together does create more than a scintilla of evidence in this case, that HEB is on constructive notice of leaks in this store.
Does that not open us up to the very problem that your friend on the other side told us would happen if we were to find that this constituted constructive notice? We're now just, every time somebody's injured, we no longer need to have any real connection between the actual cause of the injury and what they would have known about it, because we'll just let a jury decide that.
I don't think so, Your Honor, because there's a plethora of cases cited in all the briefing in this case that don't get there on constructive notice. The Peperinsky case, for example, is one. There's no evidence in the record that was from a rain. There's no evidence that there were leaks in that portion of the convention center. There are the Coward case that HEB cites too. Is a case.
Anytime there's rain and anytime there's a grocery store that's ever had any leaks, we're now going to a jury?
If they've had, at some point, Your Honor, they've crossed that threshold where now every time, if the store leaks every time it rains, I would agree.
A 60,000 foot?
A 60,000 foot store where there's been water on the floor for 2 hours, if under those facts, I would agree. That's up to a jury to decide.
Even if every time it rains, the leak is just in one tiny piece of the northeastern corner, they're on constructive notice for the southwestern corner as well?
In that particular case, maybe not, Your Honor. But then they would know where the leaks are, and then they would deal with those leaks on the constructive notice. To say that these are limited to a quadrant, I think is what the bench book will show the court, is that they're not. They're throughout the store.
Any further questions? Thank you, Mr. Sloan. Mr. Jefferson, you have 5 minutes.
The question that is at issue here is how long had the water been on the floor? And counsel just said that the water had been on the floor for a period of hours, I think is what he said. There's no evidence that water had been on the floor for a period of hours. And this goes to your point, Justice Bland. It is in premises It's a transient nature. Customers, kids are dropping their sippy bottles, and customers are dropping their water bottles, and you don't know. You have to have some sort of way to tie the condition on the floor to notice of the premise owner for there to be liability. And here, there's no evidence. They concede there's no actual notice that there was water on the floor. And so the question is, was there constructive notice? The highlighted yellow, there's all these dots with the highlighted that Justice, you pointed out a while ago, Huddle. Again, the area where the toy aisle is, 0. There's no evidence whatsoever that.
But are you looking at page 138? Is that the one?
Yes.
So, I mean, these go way outside just the southwest quadrant.
Do you see the white rectangular box at the bottom?
Yeah.
Above that is where the toy aisle is.
Yeah, but we have stuff that's, just barely to the left of it and just barely to the right.
These are 40 feet or more on either side. So the standard, if I were writing the opinion, the standard is that there must be some connection between the previous known leak and the dripping water on which the plaintiff fell. There must be some connection, and here there is none. In Rodriguez,
if this
there
happened,
was.
2 days before the event at issue here, it would seem to me a much harder case for you. But this was in January, I guess, and so we're talking about 3 seasons have gone by, and if these have been completely repaired and there have been no further rains, then I think that standard would make more sense. But if we have them just dotted around here a couple days before, would you agree with me or not?
Well, I respectfully no, but the reason is that in this area, never had there been
I guess it depends what we mean by area.
Toy aisle. Above,
Toy aisle, I know,
no leak in the toy aisle ever
If
before
they're just
or after.
sporadically around the store, then it seems to me much harder to say that you can't be on notice that when it rains, they're going to happen. So when I thought that it was just strictly in that southwest quadrant, that sounded like a very powerful argument. And it might still be if that is the case at the time that this happened instead of 9 months earlier. So I mean, I'll go back and I'll think about, the distance and stuff like that, but if, I don't know what the distance across this courtroom is, but if there's a big leak right here, and there's a big leak right over there, 2 days before, there's a big leak right above where you're standing right now, that doesn't strike me as, how could we imagine that could happen?
I would ask the court, when you're going back to look at the record, look at it's the third volume, pages 2161, 2198, and 2549 through 50. This shows that in the area where the remodeling was happening, that's where, during these renovations, the subcontractors punched holes more than once, and that's why.
If I'm understanding where you all are saying in relation to this page 138, it looks like where you said the toy aisle is just right flat where a lot of these yellow spots are. So we need to, that's what this looks like.
Yeah, I think you pointed to
Yeah.
Justice Young, but we couldn't see so could you point so that we could see it as well?
Your Honor, may I approach, and I'll just walk by real quickly?
No.
Okay, well, so it's hard to see, but this, I'm looking on page 138.
Yeah.
Looks like it's above the long
Above the long, kind of warehouse-looking
But which way does
fixture.
the roof slope?
The roof is sloping, well, I don't know that the record will say.
But you would think if water's leaking through a sloped roof, it might run down the inside of the ceiling.
I believe that the record shows it's sloped away, but the point is, in this area, above that rectangular portion, before and after, a 1 year period before, a 1 year period after, no leaks in the toilet.
Are you noticing that on the picture that you directed us to at the beginning, that it is turned upside down on page 138? And so it looks to me like where you said before the leak is right where those yellow dots are.
No, Your Honor, I'm sorry. On each of these, you have this one rectangular spot.
Yes.
Above it, on each page, on each picture,
Yes.
is where the toy aisle is.
Right.
And there is no leak, and there is no structure. My point is, no evidence of constructive knowledge, no evidence of actual knowledge, no connection between prior leaks and what the plaintiff testified was a leak here. On that basis, summary judgment has to be granted, otherwise you burden premise owners on every rainy day with complete surveillance of their premises, and I think this is not a tort system that can survive long with an economy that
Thank you,
would
Counsel.
require wasted resources on that point.
Counsel, could I just ask one other question? Just a record, it's noted in your merits brief that there were 4 district judges on the Bexar County District Court Central docket. Were all 4 of them different?
Yes.
So we've had, I guess, 15 different judges now in total look at this thing? 6 different Court of Appeals justices, 4 different district court judges, and then the 9 of us?
That's right, and 2 times summary judgment granted for HEB.
Right.
And twice reversed by the Courts of Appeals.
Any further questions? Thank you, Mr. Jefferson. Thank you to all counsel. The case is submitted, and the court will take a brief recess.
All rise.